Today, I will be presenting, Robert Galliano, a member of Copenhagen and Copenhagen, will be presenting a webinar on the sandwich generation. Today's agenda. What I'm going to be covering today is what is the sandwich generation? And then I'm going to go into what we need as legal tools to protect minor children, protecting adult children. I'll talk about protecting family members with special needs, and I'll talk about protecting parents. The main source of information will be given to you through the lifespan of an individual that we will be responsible for. But before I begin, I want to show you that we are 8 lawyers strong. Actually, we're 5 lawyers strong. And we are a specialized law firm, and we have unbelievable support staff. There's about 35 or 40 support staff. The majority of them are paralegals with college degrees. And we are a wonderful law firm that specializes and have been specializing for over 40 years in nothing but estate planning. We have offices. We have actually 8 offices. We have 8 offices throughout Southern California. I am currently in the Temecula office, and that's where I am speaking from. So let me start over. Let me start at the beginning here. Here we go. Sandwich generation. We're not talking about food when a family member needs to take care of parents and minor children. The definition of a sandwich generation, the statistics are, or the profile is basically that middle-aged adults, generally in the age of 40 to 50 years old, are caring for adult children or adult parents at the same time that they're caring for minor children. And interesting enough, the percentage of adults in the 40 to 50 age range that is taking part as being a sandwich generation member is an astonishing 47% of that population. That is unbelievable. 47% of the middle-aged adults are in some form or another taking care of minor children, adult children, and parents. And you may be responsible for taking care of, again, minor children, adult children, children with special needs, parents, and also parents that are needing advanced planning. So again, what is the sandwich generation? It's simply where we have a segment of the population, which I mentioned could be up to 47% of the middle-aged adults between ages of 40 and 50 who are taking care of minor children and or adult children and parents at the same time. So what is involved is an unbelievable amount of resources, not only financial, but emotional, that get involved. And there's also a major component, which is the legal component. And what I want to focus on today is the legal components that I think that everybody should have in their estate plan in order to deal with the responsibilities and the obligations that you may have if you're part of the sandwich generation. So, like I mentioned earlier, I'm going to start with minor children, then I'm going to progress to adult children, then I'm going to progress to children with special needs and so forth. And I'm going to end talking about protecting their parents. So when we talk about protecting minor children, we don't think of a possibility that I'm going to address today is not often talked about, but I want you to focus on the following. Obviously, when you have minor children, you got married, you decided to start a family, children were protected, you protected them, you make sure that they got their shots. But if you leave, for example, your children when they're young with a babysitter, and the unthinkable happens, and your children at home with a sitter, and you don't come home because there's been an accident, what happens? The babysitter is not a legal person responsible for the care of their children. And the babysitter's knee-jerk reaction may be to call the police. And then if the police arrive, and the first thing that they're going to do is they're going to try to find out who is legally responsible for the care of the minor children that are at home. And when they don't have an answer to that, they will call in Child Protective Services. And then Child Protective Services can't take the minor children and hold them until a determination as to who the guardians are and so forth can be determined. So it's really important because the majority of young parents don't have a plan to cover the situation that may occur. And if there's no plan, then what happens is that you wind up with guardianship hearings, you wind up in front of a judge, and the judge is going to decide then pretty much the future of the child, who's going to be the guardian, who's going to take care of them, what are the finances going to be used for the care of the children, and so forth. And so it becomes a disaster when you don't have a very basic plan to protect minor children from the issues that come arrive. For example, when something happens to you and you don't have a plan in place. You have not identified, for example, temporary guardians. You have not identified permanent guardians. You have not identified, for example, anyone to have a medical directive for your minor child. A medical directive for your minor child is similar to the advanced health directive that we have over adults, but there is a code section in California that would allow you to have a medical directive authorizing an adult to make medical decisions for your minor child. Your estate plan should also be set up to hold monies that would be provided to a minor child. A minor child cannot inherit. So in order to avoid guardianship hearings, you can do so by leaving the money for them in a child's trust within your trust, and you can identify how the money will be used, what kind of staggered distributions, for example, by age or over time should be given to the child, and you can identify then who the reliable trustees are, who are the reliable guardians. And again, like I mentioned, you need to make sure that you name temporary and permanent guardians that you have identified who would be responsible medically for your minor child. Let me go back. So when we then talk about protecting adult children, the importance of protecting adult children are also not often thought about, because when a child of ours, yours, reaches, for example, the age of 18, they are an adult. But for us as parents, they're still kids. And so we do not think of them as a separate adult. We still think of them as our child. But the reality is that they are an adult at this point in time. And therefore, they, your child, the 18-year-old child, should have a durable power of attorney, which would give you authority to sign the name on behalf of the child and make financial decisions for this child that has turned 18. It's important that they get a durable power of attorney when they turn 18. Also, because they are adults, even though you're the parent, you should have an advanced healthcare directive so you can have the authority to make healthcare decisions for your adult child. In your estate plan, you should also have trust for your adult children. Why? Because the children inheritance needs to be protected from potential lawsuits. If the adult child, for example, is married, perhaps from potential divorces, you may want to have in your trust education provisions as to how and when they would get some of the money that you left them. Identify who the managers would be of the adult children's trust, and also provide in their provisions to avoid the money being spent if they should become addicted to drugs. You have the ability in your estate plan to provide adequate legal protection for minor children and adult children. it's important that you understand the following, and that is, again, that the protection for your minor and adult children, and also children with special needs, is in your estate plan. That is where the protection comes from. Now let's move on. If a child of yours is a special needs child, you should realize that they are going to be needing a specialized type of trust. That type of trust is called a special needs trust. Sometimes they're called supplemental needs trust. And those legal entities, those trusts, are used to be able to manage monies that are left to the child so they can continue to remain on the government programs that they have qualified for. Statistically, 17% of children between ages 3 to 17 have some form of disability. And almost 11% of US adults wind up with some form of disability. The protection of a child with special needs is important because you, again, can identify whether you have left them with sufficient funds so they can be self-sufficient when they're an adult. You can identify within the special needs trust who the managers are. And again, leaving money in a special needs trust or supplemental needs trust would allow them to keep their government benefits, because if you give the inheritance outright to them, they would then have more money that they're allowed to have to keep their benefits, and they could lose their benefits. And in some cases, like Medi-Cal, upon death, they may seek reimbursement. And again, they may not be able to requalify until the inheritance that you gave them is depleted. There are several types of special needs trusts, and you have to work with a law firm that understand the differences between these trusts so that the right trust can be prepared for the special needs child. There's the first party trust. That's a trust that is created with the child's, it's funded with the child's own money. The third party trust is a trust that is funded with somebody else's money. And then there's the pool trust, which is a trust that is basically managed by a outside organization, another organization, and they administer the trust in combination with the pooled benefits of other individuals. So there are three types of trusts. They all have different requirements and so forth. The purpose of these type of trusts is to supplement and not to supplant any type of public benefits. One of the biggest problems that parents make, and just this morning, for example, I had a call with a client, and here is the mistake that they make. Nobody thinks that a child of theirs is going to become special needs, and therefore they fail to prepare the requirement within their trust to have a special needs trust prepared either upon their death, or they don't have a trust prepared while they're alive. So when they die, the inheritance has nowhere to go except directly to the child, and then the child will be removed from any of the benefits. Not having a special needs trust can cause the loss of their benefits. And again, it's like the government inheriting the money that you would have left for them. It's just a big mistake that parents make, thinking that the calamity or the potential problem of having a special needs event occurring in your life for a child of yours may not happen, because it happens all the time. Within our legal documents, we at Copeland Bar have included authority to have a spouse or a successor trustee act to obtain Medi-Cal benefits. We've added the latest IRA rules under the Secure Act, and we've added the ability to provide for the protection of special needs beneficiaries. Let me move on now to protecting parents. We talked about protecting minors. We talked about protecting adult children. We talked about protecting children with special needs. The protections for the minor, adult, and special needs child, that protection is within your estate plan. Now, the protection for parents, the primary tool for caring for your parents, is in their estate plan. That's a very important distinction. Let's talk about protecting parents. We all know that not every day is a good day. You, as the matriarch or patriarch of your family, stresses will come into your life. You have to maintain your position at work. You have children, you have health issues to take care of, and you have maybe parents that you have to take care of because they are reaching an older age. Like we indicated before, that there's 47% of the population between the age of 40 and 50 that are in the sandwich scenario, taking care of children and parents. A lot of times the parents, for example, they may have difficulty paying their bills. They don't understand this. They don't have the ability to research. They don't have the ability to evaluate whether the bill is current or not current. They don't have the ability to make decisions, simple decisions like maybe they have to have a cleaning person come in and take care of the house. And often, as we know, parents, as they get older, they often become paranoid or suspicious. They forget things. We've had clients, for example, think that children were stealing their money, their jewelry. And a lot of times, more often than not, they're unwilling to cooperate. They don't want to eat. They don't want to do that. We all know that these circumstances come with aging. And an example of a couple of case studies, these are real case studies, is in the first example, Jill's mother, she could no longer take care of herself. And by that, I mean, she could not understand the bills that she was getting. She was having trouble, for example, even opening the mail. She did not know where she was putting the mail that she received. She would put them in a drawer, never look at them. And typically what a lot of the seniors do, they forget to pay the bills. And in this example, Jill's mother forgot to pay the electric company bill, and they, like they do, shut off the electricity. Well, Jill's mother had medications that were supposed to be kept refrigerated. And you can imagine then what happens, right? The medication that used to be refrigerated, that should have been refrigerated, was spoiled. By the time they find out that the mother had not paid the electricity, it is turned into a real disaster. And another case, which is true also, is that in this example, James' father, he had not paid the property taxes. And we both know that if you don't pay your property taxes, eventually the state is going to take it home. So here's an example where the lack of paying property taxes, because he did not remember that he had to pay property taxes, or he did not know how to go and find out if he owed taxes, and the state was getting ready to take his home. These are true examples. What James and Jill learned is that there is no playbook for taking over their parents' financial and legal affairs. There is no set of rules. This is what you have to do. And in these examples, the parents, they had an estate plan, but like most estate plans, it was outdated. The children, James and Jill in this example, they had no access to the parents' accounts. They could not obtain any of their financial or medical information. We get phone calls about this situation all the time. And one thing that I think it's a common misunderstanding, and that's why I have it here on this particular slide, and that is that trust and powers of attorney, wills, they're all controlled by different laws. One common misunderstanding is the following. A child will have authority under financial power of attorney if the bank accounts that the parent has or title in the name of the trust. So the child, thinking that they have a financial power of attorney, they can access the bank accounts that is registered and owned by the trust. They cannot, because the accounts are titled owned by the trust. And in this example, the child is not a trustee of that particular trust. All they have is the financial power of attorney. Likewise, if you're a trustee of a trust, but the bank account is not in the name of the trust, you cannot, if the trustee is not on the bank account that is not named in the trust, they're not going to be able to access the account. So this is a common problem that we see all the time. We get calls on this all the time. Another thing, if you don't have HIPAA, that's the instructions where someone has given to you so you can access their medical records. And if you don't have your name on powers of attorney, you may not be able to access records, and institutions, for example, may not even speak with you because you don't have the authority to access the accounts. You need to place yourself on your parents' powers of attorney as primary agent, not backup, so that you can access records, so you can contact institutions, so you can help your parents. On your parents' powers of attorney, you should be named as the primary agent. You should have a backup agent, of course. And these powers of attorney, your parents need to update these before incapacity sets in. Once this incapacity sets in, they will not be able to update these documents. On your parents' advanced healthcare directive, you should be given the authority to act on their behalf. You should be the primary agent again. You should have a backup agent. Again, these documents need to be updated before your parents are incapacitated. And you also have to have the HIPAA, a document that would allow you to access medical records for your parents. These are simple things that you can do so that you have access to be able to help your parents look at the bills, pay for the bills, access bank accounts, find out what medical, maybe what medications they're taking, and so forth. Your parents' trust must be current. Remember, they're the creator. The parent is the settlor, but you can be named as the acting trustee. In a lot of situations, once the parent becomes, I'll call it disabled or has disability issues, perhaps maybe you should be placed as the acting trustee. If your parents, for example, don't have updated documents, they don't have an estate plan, they don't have powers of attorney, and they become disabled, and the proper legal documents are not in place, the only process then that's available for someone to be able to care for them is called a conservatorship. The person who's going to be taking over the responsibilities of the conservator is a court-appointed representative or protected of the adult who's incapacitated. Their responsibilities under the conservatorship rules is overseeing finances, establishing and monitoring the physical care, managing living arrangements. But the court oversees a lot of these decisions. You do not want to be involved with the conservatorship if you can help it. It can be avoided by having your parents have a current updated estate plan, proper powers of attorney, proper advanced healthcare directives. Let's talk about now what happens when the parent requires more care than simply paying the bills. In other words, the disability of the parent has escalated to a more stringent care situation. What do seniors worry about the most? Well, statistically, they worry about becoming ill. They worry about losing their memory. They worry about becoming a burden on you, the family. Obviously, outliving the money. Or perhaps maybe they're going to have to care for other relatives that are aging. And outliving the spouse. Dying is the last thing on the bottom of the concerns. That main concern is just becoming ill, losing the memory, becoming a burden. In other words, they do not want to become a part of the burden of the sandwich problems, the sandwich generation problem. We are living longer. You know that. Your parents are living longer. As you age, rise in age-related illnesses can impact your health, and it can last for years. You may wind up with diabetes. You may wind up with Alzheimer's. You may wind up with Parkinson's disease. So when these circumstances with these illnesses appear, because we're living longer, and as we age, our body starts to age, obviously, we're not dying like we were in the 40s and the 50s, and we need to be able to protect the estate from loss due to these illnesses and incapacity, because when you have to pay for the care of these illnesses, as you know, is super expensive. And we have to have a plan for avoiding being in a nursing home. Nobody wants to be in a nursing home. And obviously, we have to make sure that they have an estate plan to avoid becoming a burden on the loved ones. This is what seniors want. They don't want to become a burden. They don't want to be part of the sandwich generation. The cost of care in California is astronomical. This is the 2023 listing of the expenses. The annual cost of home health aid or home acre is over $80,000 a year. Assisted living, they have somebody come into the home, can cost up to close to $70,000 a year. Nursing home, semi-private, $130,000 a year. And a nursing home, a private room in a nursing home can run close to $160,000 a year. Now, who has this kind of money set aside for these contingencies? How do you pay for these long-term care issues that come up? How do you protect yourself from these, I'll call it, circumstances that which you have no control over that may happen in your life? Do you have sufficient monthly income to pay for these bills? Do you have enough savings in the bank account to cover these astronomical yearly expenses? Do you feel that you have to sell your home in order to cover these expenses? Are you going to depend on your family? Will you become a member of the sandwich generation? Did you buy long-term care insurance? Or if none of these help you, you may have to then rely on government benefits. There are two major types of insurance that are run by the government. Medicare, which you know is generally when you're 65 and older. Medicare Part A, Part B is for nursing, not nursing home. Medicare pays for medical doctor visits, for hospitalization. Medicare is very limited for paying for long-term care. They only cover 100 days. The first 20 are free. The next 80, there's a copay. And then there's the other program, insurance program called Medi-Cal. Sometimes it is called Medicaid throughout the United States, but we here in California call it Medi-Cal. Medi-Cal is the program, federal and state program, that is created to pay for long-term care stays. So we need to understand that there is a way for the government to pay for these long-term care issues that may come up. And as late as this year and also beginning of next year, I want to advise you that there's been some major changes in the legal rules that are part of Medi-Cal that was passed by Assembly Bill 133. There's two phases. Phase one, which has already been implemented, that increased the amount that you used to be able to keep, which is only $2,000. It increased it to $130,000. And if you were married, then you could have as much as $195,000, because on top of the $130,000, they would add the $65,000 for the spouse. And any additional members that would live in the same family unit, you could add another $65,000 to be able to have as the amount of money allowable in addition to any exempt assets, so you could qualify for Medi-Cal. That's a big change from the old $2,000 limit that existed. Going forward in 2024, the limitation as to the amount of assets that you can have is going to be completely eliminated. The amount of assets that you'll be able to have going forward in 2024 is pretty much unlimited. So what is going to be counted in order to determine whether you qualify for long-term care Medi-Cal? And that is, they're going to look at the income that the applicant is receiving. And that is where the new law is going to be in a few months. What I want you to take from this discussion is, do not be afraid of Medi-Cal. Embrace it, understand it, work with a law firm like Kopenbarger so that we can help you plan in case your parents are facing issues that are what we call long-term care issues. Now, this is how we can help in this area. There are 3 areas of planning. Pre-planning is always the best. That is you, or in this case, we're talking about the parents, your parents having a complete estate plan, having the right trust, the right powers of attorney, having the right ages listed. Pre-planning. Your parents have the capacity, you're not in a crisis situation. The next phase, non-crisis planning. You become aware of an impending medical situation. Maybe your parents have been diagnosed with Parkinson's disease. Maybe there's been a severe fall. Maybe there's been an onset of Alzheimer's. This is non-crisis planning, but you've been aware of an impending situation. This is probably where you should take action. If you have not taken action in the pre-planning, you need to take action when you have been aware of an impending medical situation. The next phase is called crisis planning. This is where it really gets tough, because generally this is where you've been sent home from the hospital when you have no caretaker resources available. There isn't an immediate need for being in a skilled nursing facility. Medicare only covered the first 100 days. You have run out of the 100 days. You now are facing horrendous bills. You have a major crisis on your hands. We do not want you to be in a crisis situation, and therefore we are always advising, do pre-planning and do non-crisis planning. Try to avoid being in the crisis planning situation. Qualifying for Medi-Cal is complex. We have to deal with the current 2023 rules. We have to deal with the proposed elimination rules in 2024. But what I'm trying to tell you is that we do this all the time to qualify people for Medi-Cal long-term care. So it's important, if you have a notice of an impending situation, remember the pre-crisis situation, come in and see us, call and make an appointment so that we can help you understand where things are. In summary, if you do fragmented planning, by that I mean maybe you look at the health issues 1 month, maybe you then look at housing issues, you talk to a realtor maybe about potential downsizing and so forth, or maybe independently you talk to a financial advisor to talk about the money issues. And you do this not in a cohesive planning with a knowledgeable firm, but you do this in fragments. And when you start to plan in fragments, all of these issues that start to add up, you wind up with the health issues causing housing issues, money issues, legal issues, and then you are winding up with major family issues, which is part of the sandwich generation problems that we are experiencing. How can we help you? Again, call us. We can give you tools to take care of your family. We can discuss and plan these things while you are alive and well, while you have the capacity to plan. We can review, update, and maintain your estate plan, and we can also review your parents' estate plan to make sure that you are properly named so you'll be able to help your aging parents. Why would you want to work with Kobenbarger? Well, we've existed since 1979. 8 full-time attorneys, 2 attorneys of counsel, and a CPA. Combined experience over 350 years. Half of us have advanced tax degrees. Half of us are certified specialists by the State Bar of California. We have 45 plus highly trained, knowledgeable support staff. We have a diverse staff and diverse skills and 8 office locations. And we do appointments by Zoom. We do appointments by telephone. We are here to help you.